Hi everyone, very good afternoon and welcome back to CrackGradeB. So let us start discussion on to the corporate insolvency resolution process, and we are going to discuss this by virtue of some case studies. These are sample case studies which are available to us, right? So let us look at it, how these kind of questions are going to appear. See, at the end of the day, having the knowledge of the procedure is utmost important because without that you will not be able to solve the question whatsoever. But these case studies, they give you a head start, right? So now let us see with that. You have to attempt these questions, and this is something which has been provided to you. This is something which has been provided to you. Let us see that. So Mr. X holds the first meeting of his team as an interim resolution professional of Jumpy Cosmetics Limited, right? This is a company and Mr. X is a resolution professional, okay? As application was made to the adjudicating authority by a joint lending forum led by Kuber Bank, who are owed 1.3 crore, which was satisfied that a default had occurred, right? So such kind of defaults have happened, that has already established. Now Richie, just a second please, just a second. Yeah, sorry for the disturbance. Now you see, Richie, who's one of the senior members of X team, asks to see X privately. Now X is a resolution professional over here, don't forget. Richie is one of the senior members and he wants to talk to X. And he reveals that his cousin is on the board of Jumpy, the company for which they are handling this resolution process, right? This particular person, Richie, has got his cousin on the board. Although Richie explains that we are not in touch and we have not talked for for last 5 years, but still, see, Richie is a forensic accountant and he is a skillful strategist, and X is very keen for him to remain on the team. X nahi chahte that Richie should leave his team, and he wants that Richie should remain there for dealing with this particular corporate insolvency process. Okay, fine. Jumpy deals in cosmetics for reconstructive surgery or as an alternative for surgical intervention, and thus holds several licenses for live animal research. ठीक है, ये अपकमिंग फ्यूचर बिजनेस अपॉर्चुनिटीज के बारे में भी बता रहे हैं. दैट जम्पी डील्स इन कॉस्मेटिक्स फॉर रिकंस्ट्रक्टिव सर्जरी and also holds several licenses for live animal research. Okay, fine. Now with reference to the above mentioned facts, you have to answer few questions. Now at the end of the day, knowledge is important, so without which we cannot solve these questions. That is understood. Now with respect to the stated position of Richie, what shall be the reasonable step? जब Richie ने बताया है that he has got his cousin on the board of Jumpy, so what should be the position of X? So Richie may remain on the team because his relationship with the cousin is a distant one. Richie has to leave the team and return to the office as he is effectively an independent director of Jumpy. Richie may remain on the team as he is a junior member without any significant influence, and Richie must leave the team and return to the office as the code of conduct places high value on independence and impartiality. See, both these options say that the Richie has to leave the team because he has got relations with a person who is director onto the Jumpy Limited, right? The company for which they are handling the case. But the reasons allocated, you can see the reason over here. He is effectively an independent director. ऐसा तो किसी ने कहा ही नहीं कि आप independent director बन जाओगे. Yes, you are having a relationship, and as per the code of conduct, you should leave. So that is the correct option, option number D. Next, with respect to the circular issued by IBBI on January 16th, acquiring certain disclosures to be made by the insolvency professional in a resolution process for transparency, by when must the disclosure be made related to the relationship between Richie and his cousins. So if there is any item that is impacting your independence, अगर ऐसा कोई भी item है जो आपकी independence को impact कर रहा है, you need to disclose it. आपको वो disclose करना पड़ेगा, and it is said that within 3 days of your appointment as interim resolution professional, when Mr. X was appointed as in resolution professional, within 3 days they need to tell about the relationship with the Richie has with his cousin, right, and how it is impacting his independence. Next is, who shall be held responsible for the loss suffered by Jumpy after the commencement of CAIIB on account of non-compliance? See, who shall be held responsible for the loss suffered by Jumpy after commencement of corporate insolvency resolution process? Why such loss has occurred? Because non-compliance with the law due to a license for cosmetic products for animal testing not being renewed on time. देखिए, once corporate insolvency procedure starts, all the powers gets shifted to resolution professional. ठीक है, सारी जो board of directors से all the powers are taken away and that is given to the resolution professional. हम उसको किसको दे देते हैं? resolution professional को. So now if there was a license that has not been renewed on time, एक license था जिसको आपने timely renew नहीं कराया, तो कौन responsible होगा? The insolvency professional will be responsible and any loss will not form part of insolvency resolution process cost. See, directors responsible नहीं होंगे, company responsible नहीं होगी, senior employees personnel responsible नहीं होंगे, because once the process has started, all the power has been shifted to resolution professional, so he is going to be responsible. Now, after the commencement of CAIIB, Mr. X shall ensure publishing of Form G for invitation of expression of interest. Now, this question suggests you that why we will be using Form G. Who is going to ensure publication of Form G? These are few informations that you need to understand. अब Form G देखो, within 75 days of the commencement of resolution process, and you have to invite entities for their expression of interest. See, how we'll be able to resolve anything? When there will be investors who are ready to invest, who are interested. For example, the sale of Air India. Okay? The government was trying so hard to get some investors on board so that they can restructure and turn around Air India, right? And they can secure an exit from the Air India. So such kind of thing needs to be, Form G has to be issued for that. Now, Mr. X shall appoint registered valuers by. So, the maximum time limit within which they have to appoint is within 47 days of the commencement of the process. Registered valuers आपको appoint करने पड़ेंगे. Mr. X, before accepting the assignment as IRP, that is Interim Resolution Professional, would have submitted Form 2. Now, what does Form 2 deals with? So, it deals with written communication to initiate corporate resolution process. Right? So, this is the written communication that yes, we are starting with this particular process. Remember the form, who needs to submit the form and what is the purpose of form. Next is assuming Mr. X was in employment at the time of considering the offer of assignment. Was in employment at the time of considering offer of assignment, you have to choose the correct answer. Mr. X can submit Form 2 only if he holds a valid authorization. Mr. X can submit and take authorization for assignment before actual date of appointment. Requirement of holding an authorization does not arise. And requirement of holding an authorization for appointment would arise if his name were proposed by an operational creditor. No. Right? So, Mr. X can submit form 2 if he has got valid authorization that this particular thing has been assigned to him. Now, there is no such case of name being proposed by financial and operational creditor. There is no need of it. Two registered valuers appointed by Mr. X have provided estimates of fair value and liquidation value. Okay. Two registered valuers who has been appointed by Mr. X has provided the estimates of fair value and liquidation value. In which of the following situation should Mr. X appoint a third valuer? See, only if he is of the opinion that two estimates are significantly different. देखो जब हम दो registered valuers appoint कर रहे हैं, they need to tell us that what is the fair value of any asset. For example, if I will try to sell this pen in the market, this is going to fetch me 100 rupees. मान लेते हैं, that is fair value of this pen. But suppose if my company is severely into losses and I want to make a distress sale, ठीक है, मुझे भी बेचना ही बेचना है. So in that case, I am going to fetch lower than the fair value. तब तो मुझे fair value से कम मिलेगा. So that is why that would be called as the liquidation value. उसको क्या बोला जाएगा? Liquidation value कहा जाएगा. And if you have appointed two registered valuers and they are giving you the estimates which are poles apart, right? So you would like to take a third opinion. आप एक तीसरा opinion लेना चाहोगे. So only in that case you have to appoint. Now this is see why the other options are significant. If the valuers disagree with each other, doesn't matter. आप एक दूसरे के काम से disagree करो, मुझे कोई फर्क नहीं पड़ता. It only matters to me if I am disagreeing with your work. Okay? Only if the committee of creditors by a majority recommends such appointment, no. All these cases are wrong. Now, Mr. X has received a suggestion from one of the creditors that liquidation value should be included in information memorandum to fetch higher resolution value. Now choose the correct answer. Liquidation value should be mandatorily included in information memorandum. Only if liquidation value due to operational creditors can be included. Liquidation value may be included. Liquidation value need not be incorporated in the information memorandum. So that is the correct answer. See, information memorandum क्या होता है? Suppose when I want to issue some shares, giving you an example, I issue the prospectus and I tell the investors all the information that is related to my company, that is related to the business activity which I am doing. मैं सारी information बताती हूँ. So information in memorandum also plays such a role in the process of corporate insolvency resolution, where you are telling all the relevant information. So these kind of thing, like the word over here is mandatorily included. ऐसी कोई जरूरी बात नहीं है. ऑपरेशनल क्रेडिटर से रिलेटेड हो तब इंक्लूड करेंगे. इफ votes have been passed तब इंक्लूड करेंगे. नो, दिस इज नीड नॉट बी. इफ यू वांट यू कैन, बट देयर इज नो मैंडेटरी कंसिडरेशन फॉर दैट. ऐसा कोई मैंडेटरी चीज नहीं है. Financial creditors are contemplating to initiate insolvency proceedings on the Mr. P, personal guarantor to corporate debtor. They have approached Mr. X to take up the assignment in relation to Mr. P. So the company Jumpy Limited, who has failed to pay the amount, there was a personal guarantor Mr. P, and now the creditor wants to start the proceeding against Mr. P. So can the resolution professional do so? क्या resolution professional ये काम कर सकता है? So Mr. X should not agree to the request as he is not eligible for such appointment. He has only been assigned the corporate insolvency resolution process for Jumpy, not for Mr. P. Okay. Now again a case study. This is something related to family dispute. Let us see that. So there is a company, Rajhan Soil Private Limited. It is a private company, right? And the owner passed away due to heart attack without any succession plan. Now there were two brothers and they were having the equal shareholding in the company. Okay. Now Naveen resigned as the director of the company, and in lieu of the same, he was entrusted control of another family firm called as Aragon Edibles, where both the brothers were partners. ठीक है. Praveen, son of Pawan, was inducted as the director in the company. Son of Pawan. See, Naveen has taken the exit and Praveen, who's the son of Pawan, was inducted as the director. Okay. In 2018, Naveen wanted to withdraw unsecured loan given by him to the company because the company stopped paying him the interest. So Naveen, who had already taken the exit, he also wanted to withdraw any unsecured loan that he has given to the company. Now, despite follow-up, Naveen was not paid neither the principal nor interest, which forced him to file an application under Section 7 of Insolvency and Bankruptcy Code. The adjudicating authority admitted the application and appointed an IRP. Pawan refused to hand over the management. He said that it is a family dispute and they will settle it soon. IRP tried to persuade Pawan, citing the provisions of IBC, and warned him. Thereafter, Pawan allowed the IRP to take inventory of the assets and stocks after 15 days from the insolvency commencement date. Now that is the case. Now let us see the questions onto it. See, Yes Bank, the only member of Committee of Creditors holding 100% voting shares, filed an appeal before NCLT to set aside the order of adjudicating authority regarding admission of CAIIB on the ground that its cash credit account with the company is regular and there is no default. Will the application of Yes Bank survive? ठीक है, तो अब यहाँ पे क्या हो रहा है, Yes Bank ने कहा कि no, we have provided a CC limit and that account is doing okay. So you should not go ahead with CAIIB. You should not carry on with this insolvency proceedings. So now see, yes, there is no default for financial creditor. No, a default has occurred under Section 7 of the code and another creditor does not have right to intervene. Yes, as the account of Yes Bank is likely to become NPA. Yes, the application of CAIIB was filed by a related party financial creditor. So correct reasoning is this: Yes Bank cannot intervene because the rights of creditors are independent from each other, and you cannot come and say no, this does not impact me, so you cannot go forward with that. That is the incorrect reasoning. So Yes Bank's appeal is not going to stand. Next is insolvency resolution professional, while taking over the control of assets, was informed that income tax department has attached the raw material go down due to default in payment of tax dues. Now, what should be the most appropriate course of action? So now, out of all the actions, they should request the income tax department to file its claim, withdraw the attachment, and if the department refuses the request or delays it, it should file an application before adjudicating authority, because Pawan has given the rights over the stocks and inventory to the insolvency professional, right? So yes, you can coordinate with the income tax department on that. Now Naveen filed a claim for unsecured loan of 1,75 lakh along with the interest 18%. IRP reviewed the accounts and found that there is no agreement to that effect on interest rate. Neither there is any resolution of the board in this regard. Matlab, resolution professional have found out that there was no contract that the company is going to pay 18% rate of interest to Naveen. ऐसा कोई contract नहीं था. So IRP has admitted the claim only for principal. Now, is he right in his decision? So see, IRP was right in admitting only the principal in absence of any evidence, because only one party is saying that I have to get 18%. That is not justified. वो justified नहीं है until and unless there is a valid contract between both the parties. जब तक कि एक valid contract ना हो, तब तक insolvency resolution professional cannot go ahead just on the basis of what one party is saying. Okay. Now, next is Yes Bank charge interest at the rate 9% on cash credit limit as per terms of sanctions even after the insolvency commencement date, and justified it on the ground that if interest is not charged, the account has to be classified as NPA. Is the bank's claim legally justified? Hear me out. Yes Bank ने charge किया इतना interest. Now, as per the terms of sanction, even after the insolvency commencement date, and justified it on the ground that if interest is not charged, it has to be classified as NPA. See, interest cannot be charged after insolvency commencement date because all the interest charges stops at that date, because after that we try to resolve it. हम चाहते हैं कि जिसको जितना पैसा देना है वो हम दे सकें. So bank must file the claim as on insolvency commencement date, right? On that date, till that date, whatever is due to you, you can file that, not beyond it. उसके बाद नहीं. Next is on review of the bank accounts. Resolution professional observed that 16 months before the insolvency commencement date, a payment of 1 crore has been made to a creditor, Argon Edibles, which Pawan is a partner. Does it amount to preferential transaction under the code? Yes, it does. It is given to a related party during the period of 2 years preceding the insolvency. So that means we try to find out that were there any symptoms of insolvency and have you done any kind of transaction in those 2 years preceding the insolvency commencement date. If you did a transaction with a related party, this is going to be treated as a preferential transaction. Next, IRP sent an email to the advocate of the debtor who was handling the matter on behalf of promoters to provide IRP all the documents in his possession within 7 days. Was IRP justified in his action? ठीक है, तो यहाँ पे see, no advocate are not covered. All professionals under obligation. IRP is an officer and he can ask records from anyone. No advocate is an officer of the court. See, you are authorized to take all the information from the company. वहां से आप सब कुछ ले सकते हो, branches से आप सब कुछ ले सकते हो, but advocates are not covered, right? So you can ask कि please provide me this information, but there is no obligation on advocates. In the first meeting of Committee of Creditor, Yes Bank asked for reimbursement of the legal expenses incurred by it on filing application. Now, Committee of Creditors approved the same and was reimbursed by the IRP. Whether reimbursement was in compliance. See, Yes Bank asked for reimbursement of legal expenses which has been incurred by it on filing application before NCLAT for setting aside the order. The first question, remember the first question which the Yes Bank filed the case with. Now, Committee of Creditors have approved the same. That case was obviously dismissed because that was not a valid case, right? So, over here, Committee of Creditors cannot sanction it. IRP should have informed Committee of Creditor that legal expenses incurred by Yes Bank are not payable. Okay, because this is not insolvency resolution process cost, right? And see, Committee of Creditor is not, what you can say, having the appropriate authority to approve such kind of expenses. Now, one of the operational creditors have filed a claim of 2 crores, claiming that he could not file it due to COVID lockdown. Now, professional refused to admit the claim on account of delay beyond 90 days. What is the option available to the operational creditor? See, आप NCLT जा सकते हैं. Okay? अपील तो आप बाद में करेंगे, but you have this particular option out of these. Next is, see, out of the available option, you have got no right, Supreme Court extended time limit, file application before NCLAT, but actually first NCLT, then NCLAT. So this option is correct. Next is IRP sent the notice of COC meeting to Pawan but not to Naveen. Naveen protested this and represented that Pawan is also a related party, unsecured financial creditor like him. Therefore, he is also entitled to receive the notice of COC meeting. What is your opinion on the representation by Naveen? See, IRP was justified in sending the notice to Pawan in his capacity as a member of suspended board of directors, though he was also an unsecured financial creditor. Directors do not have any right to vote in the committee of creditors meeting. ठीक है, इनका कोई right नहीं होता, but you have sent the notice to Mr. Pawan because he was a board of director as well. वो board of director भी थे, and by any virtue of sending this notice, although he is not eligible, वैसे भी मिस्टर पवन इज नॉट एलिजिबल टू वोट इन दी सीओसी मीटिंग, वो वैसे भी वोट नहीं कर सकते. सो दैट इज व्हाई IRP was justified. Now, if IRP files a report certifying constitution of a committee of creditors, by when this report must be filed to the adjudicating authority? So, report must be filed within 23 days from the date of commencement of IRP. You have to certify that yes, committee of creditor has been constituted, and that needs to be done within 23 days. So this was a prototype of how the case study based questions can be asked. This is it for this particular class. Thank you so much for joining in.